Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. Jurisprudence class. In this class, we are going to discuss the binding authority of the precedents. Normally, you pronounced as precedents, but the pronunciation is correct pronunciation is precedent. Precedents. Simply to say, precedent means previously decided case law. Before the codifying of the different acts, you know that before the codifying of our acts like IPC, CRPC, CPC, Succession Act, all these things, only one law was there, that is common law of England. We have to foster respect to the common law of England. Even though we have written our own constitution, in Article 51 of the Constitution of India, you may see that you have to respect, you have to give value to the common law, because common law principles are very necessary for deciding to the correct, for arriving to the correct decision. So the judgment, the precedent is otherwise called as the judge-made law. So how judge-made law? Because they can make law. But the decisions given by the previous judges, they can be accepted as a law. So this is previously decided case law. So precedent. According to Bentham, precedents are judge-made law. It means the guidance or authority of the past decisions. Authority of the past decisions for the future cases. So if some murder case comes to the notice of the judge, he can look at the previous decision and he can say, oh, this thing, and he can think over that matter tomorrow. Oh, it may happen like this also. So only such decisions which lay down some new rules for the principles, they are called as the judicial precedents. Right. So in this connection, I want to tell you a very important case, negative and positive. First of all, let us discuss the negative example. Director of Settlements versus Sri MR Apps Rao, 2002. So please remember, in this case, MR Apps Rao, remember, he worked as the Chancellor of, Vice Chancellor of Andhra University, and he was the Zamindar of Nuzveer Samsthanam, and he has filed a case against the Director of Settlements. He was successful in the lower court. Of course, anyway, Director of Settlements went to the appeal court. So appellate court disclosed, they clearly said that it is necessary to follow the law declared by the Supreme Court, judge-made law. It is taken as a precedent. So the judgment given by the lower court has been annulled with the precedent. Likewise, an important case from USA. This is Brown versus Board of Education. Actually, the continuation is Board of Education of Topeka. Brown versus Board of Education of Topeka, 1954. Right. Previously, there was a there was a precedent in the case of Plessy versus Ferguson, where it was stated that both the white people, Americans and African Americans, they were treated as equally but separately. Equal but separate. Equally means, yes, in the eye of the law, everybody is equal. But separately, that means, suppose if the African Americans want to travel, they have to take a separate bogie, they have to get into separate bogie in the trains. Likewise, they want to catch a taxi, theirs are separate. If the students want to take a class, they got admission, theirs is a separate class, like that. In the view of the government, it's equal, but they are giving a separate treatment. This was challenged in this particular case, Brown versus Board of Education. Brown's son, he wanted to get admission in a southern state. Actually, he migrated from St. Louis, where the mixed people, that is Americans and Africans, both used to combine study in the school. But here, there are separate schools. So he did not agree, but he challenged the same. Ultimately, the Supreme Court clearly stated that, USA clearly stated that should be equal and not separate. So please remember, no but has gone away. Equal but not separate. Previously equal but separate. That's right. With this judgment, yes, the appeal is taken as a precedent, and later the so-called civil disturbance between the Americans and Americans has withered away. Now everybody is being looked after. Of course, time have also changed. So this is the importance of the precedent. So please remember, this has got authority. So this is an authoritative decision. So such the decisions are compiled and they are published in the reports. You can see them and you can follow them. So there are two types of precedents. Please remember, one is authoritative precedent, second is persuasive precedent. By its meaning itself you can know what is authoritative means. The judges must approve whether they like it or not, whether they agree it or not. When a precedent is there on a particular, if it is authoritative, you have to accept it. And persuasive, it only indirect or it will serve the purpose if you like it, otherwise you can leave it. So these two types of precedents are also important. So please remember, the legal literature, they include the decided case laws or reported case laws which may be cited and followed by the courts. What is the importance of the precedent? Please remember, number one, authority of the past decisions for the future cases. That is more important. Second is, they can be cited. The precedents which are previously decided case laws, they can be cited and they may probably followed by the courts. If it is an authoritative precedent, they have to follow. Then please remember, precedents must have opinion juries. So they have the jurisprudence. So definitely the jurists, they have to agree for the same. And please remember, they must be followed for a long time and they should not violate any existing statutory law. This is also more important because American law, it may be different. That precedent cannot be put into execution here. This is another problem. Now we are going to discuss a few more case laws, very important precedents. P. Ratnam versus Union of India, if I am correct, 1994. So Ratnam is none but Nagbhushan Patnaik case. So you know, he is a very popular man, teacher turned into Naxalite in Srikakulam district. Okay. Anyway, he wanted to commit suicide, so it was taken as a case under section 309 of the IPC. 309 punishes the people who attempt to commit suicide. So in that case, the matter came to the Supreme Court. So Supreme Court held that no, it's not constitutional. 309 is unconstitutional according to Article 21. Yes, the state has to protect the life and liberty of each and every individual. So you cannot commit suicide. But another precedent, another judgment in case of Jian Kaur versus State of Punjab, 1996. Yes, here they say right to live means right to die. When you say right to live, Article 21, yes, it means as to say. So when the person has become or has been in a vegetative stage and there is no hope of getting any treatment, any cure, then definitely it is better to die. Of course, not directly, at least indirectly. The pipeline which supplies the so-called gas to him, if it is obstructed, he will die. Is it not? So, it is constitutional. This is another precedent. And third one, Sarita versus Venkat Subbaya, 1983. You all know, this is a case relating to Section 9 of the Hindu Marriage Act or restitution of conjugal rights, wherein Honorable Justice P.A. Chowdhury, late, he clearly held that it is against to the bodily integrity. She can choose to whom they live, with whom she lives. So that is Section 9. But that precedent has been overruled by Sarojini Rani case. So Sarojini Rani versus Sudarshan Kumar, 1984. So here they said our system, that is marriage system, is definitely sacrosanct and you cannot say that it is her integrity, she can have her bodily choice like that. It's not correct. So ultimately, wife and husband should live together, even though there are some skirmishes. Yes, they have to adjust themselves, that's all. You can't say that she can reject him like that. So this is a judgment which overruled the decision of Sarita versus Venkat Subbaya. So please remember, such overruled precedents, please, you should not furnish. Otherwise, if you furnish the same, you will be taken as a contempt. So I think it's getting 10 minutes time. So I think you might have understood precedent. Precedents are previously decided case laws which are useful for the present generation. They are otherwise called as the judge-made law. If you know this much, it is sufficient. Please go through the cases like Brown versus Board of Education, or P. Rathinam, Jian Kaur, Sarita case, Sarojini Rana case, as well as MR Apps Rao case. If you go through them, read them thoroughly and enrich your knowledge. With this, I am stopping. Thank you very much.